Hello and welcome to Common Sense Lawyer Frequently Asked Questions. Our office is located in Saskatchewan, so if you are watching this video and are somewhere else in the world, the information may not be applicable to you. In addition, these videos are for informational purposes only. If you require legal advice, please consult with a lawyer. Today's question is, what is involved in probating a will? So, when a person with a will passes away, their executor, the person that's in charge, may apply to have the will probated. This is not necessarily always needed. You can discuss with a lawyer whether or not it's going to be necessary in your particular situation. People may choose to do this themselves, or they can hire a lawyer to assist them with the process. To probate a will, the original will is needed along with the death certificate of the person who wrote the will. The executor needs to provide an estimate of the total assets and how they are and where they are held. So, for example, the executor is going to have to say something like, okay, so it's a savings account, it's held at CIBC, this is the account number, and there's 15 grand in there. So if there's not a lot of knowledge as to the assets that are there, that might be a kind of tricky process. So estimates are fine. And then as you gather more information as an executor, you can always do a adjustment of that property statement that you're making, or statement of property. There might be other documents needed depending on the situation, and there will also be additional documents that need to be submitted to the court. So this is a court process, but it is not litigation. You can litigate an estate, but that's for a separate video. So yes, you do have to have the will probated by the court if you need it probated, but it should not be a litigious process. Other documents that you might need are additional death certificates of interested family members, perhaps, and there may be more. Your lawyer will be able to provide you with more details. When the application for probate is submitted to the court, there are going to be court fees that need to be paid, and the breakdown of court fees is a little complicated. So I am going to do a quick screen share to try and help provide some more clarity about what that looks like here. So I will do a quick screen share of what I am looking at. So we're here at sasklawcourts.ca, and we're going to select probating an estate. Okay, so here's some good information about why you might need to probate an estate. And then down here, I'm going to click fees, and it's going to tell me a little bit about the fees. So this part here, $7 on every 1,000 of the value passing through the estate, those are probate fees. Those are paid directly to the court. So even if you do not hire a lawyer to help you with this process, that is still money that needs to be paid for the court. Unfortunately, this is before you've received any of the access to the estate. So usually for people, this is out-of-pocket money. And then you're also going to need $200 for the application fee, and then you're going to need $25 for issuing a certificate of no infants when one is requested. So that's, again, one of those documents, and a lawyer will be able to tell you if you're going to need one of those documents or not. If there's no land, you're probably not going to need one of those. So that is where you're going to find those fees there. If you have more questions about probating a will, please give us a shout, and we would be happy to answer as many questions as you have. Thank you for watching, and have a great day.